All right, guys, I wanted to go over a court case which is over 50 years old at this point, but it's as relevant as ever. It's known as the First National Bank of Montgomery versus Daly, and it's also known as the Credit River case. Now, this trial took place in December 1968, and there was an attorney by the name of Jerome Daly, and he bought a house in Scott County, Minnesota, but he refused to pay the mortgage on the grounds that the bank didn't actually loan him money, but instead created the money out of thin air, and thus legally he wasn't obligated to pay since they hadn't actually put anything up as value. Now, Mr. Daly is correct here, because the Constitution of the United States is the supreme law of the land, and anything in contradiction to it is void, period. In Article 1, Section 10, Clause 1, clearly states, "No state shall coin money, emit bills of credit, or make anything but gold and silver coin a tender in payment of debts." Now, that local bank, because it used Federal Reserve notes and got the money issued from the Federal Reserve, which isn't a singular bank but made up of multiple banks across different states, it was ruled that it was one and the same bank. Therefore, that currency issued, if it was created out of nothing, held no value, and therefore the judge ruled in his side. So if our currency isn't backed in gold and silver and is in fact generated out of thin air using the fractional reserve banking system, any money not issued by Congress that is not backed by gold or silver is meaningless. And Mr. Daly won his case. Like I said, the judge sided with him. The law will try to tell you, though, that the decision was appealed when in fact it wasn't. So when they wanted to file their appeal, the bank, they were required to pay a $2 fee, and they had to pay it within 10 days of the decision being made. So what they did was they took 2 Federal Reserve notes and tried to pay. They wouldn't accept that as payment. The reason they wouldn't accept it as payment is because the decision of the trial was that the money they were using and issued out of thin air, the Federal Reserve notes, were determined to be illegitimate currency. So because they were illegitimate currency, you couldn't then use that currency to pay the court for the appeal. To explain it a little better, it would be like if you got caught using monopoly money to try and pay a bill, then you get arrested and you go to court, and after being told, hey, that's not legal currency, you then try to pay your court bill with the same monopoly money. That's basically what they tried to do, and it didn't work. And actually, it should be noted that the judge, Mr. Martin Mahoney, died suspiciously 6 months after the trial. And he was adamant to the end. He wasn't having it. He was not going to give in to the bankers. And Bill Drexler, who was his associate justice, went on the record and said, "The money boys that run the private Federal Reserve Bank soon got back at Mahoney by poisoning him in what appeared to have been a fishing boat accident, but his body was pumped full of poison in June of '69, less than 6 months after the trial." So I'm going to go ahead, get into some of the details of this case and let you decide for yourself. But this is a case which has not been vacated. Yes, there are jurisdictional issues, but the appeal was never filed properly. Therefore, this decision still stands. And that's why they don't want you to know about it. They don't want you to hear the arguments made, because the arguments are sound and they would hold up in any court because they're self-evident and they're true. So without further ado, let me just get into it. All right, this article is off foreclosurefraud.com. A Minnesota trial court's decision holding the Federal Reserve Act unconstitutional and void, holding the National Banking Act unconstitutional and void, declaring a mortgage acquired by the First National Bank of Montgomery, Minnesota in the regular course of its business, along with the foreclosure and the sheriff's sale, to be void. The Credit River decision, handed down by a jury of 12 on a cold day in December in the Credit River Township Hall, was an experience that I'll never forget. The Chief Justice of the Minnesota Supreme Court had phoned me a week before the trial and asked me if I would be an Associate Justice and assisting Justice Martin V. Mahoney, since he had never handled a jury trial before. I accepted, and it took me 2 hours to get my car running in the 22 below zero weather. I got to the courtroom about 30 minutes before the trial and helped get the wood stove going, since the trial was being held in an unheated storeroom of a general store. This was the first time I met Justice Mahoney, and I was impressed with his no-nonsense manner of handling matters before him. My OB was to pick the jury, and to keep Jerome Daly and the attorney representing the Bank of Montgomery from engaging in a fistfight. The courtroom was highly charged, and the jury was all business. The banker testified about the mortgage loan given to Jerome Daly. But then Daly cross-examined the banker about the creating of money, quote, out of thin air, and the banker admitted that this was standard banking practice. When Justice Mahoney heard the banker testify that he could, quote, create money out of thin air, Mahoney said, "It sounded like fraud to me." I looked at the faces of the jurors, and they were all agreeing with Mahoney by shaking their heads, and by the looks on their faces. I must admit that up until that point, I really didn't believe Jerome's theory and thought he was making this up. After I heard the testimony of the banker, my mouth had dropped open in shock, and I was in complete disbelief. There was no doubt in my mind that the jury would find for Daly. Jerome Daly had taken on the banks, the Federal Reserve banking system, and the moneylenders, and had won. It is now 28 years since this landmark decision, and Justice Mahoney is quoted more often than any Supreme Court justice ever was. The money boys that run the, quote, private Federal Reserve Bank soon got back at Mahoney by poisoning him in what appeared to have been a fishing boat accident, but with his body pumped full of poison in June of 1969, less than 6 months later. Both Jerome Daly and Justice Martin V. Mahoney are truly the greatest men that I have ever had the pleasure to meet. The Credit River decision was, and still is, the most important legal decision ever decided by a jury, and this was written by Bill Drexler, the Associate Justice whom I mentioned earlier, in his own words. And this is the judgment and decree. The above entitled action came on before the court and a jury of 12 on December 7, 1968 at 10 a.m. Plaintiff appeared by its president, Lawrence V. Morgan, and was represented by its counsel, R. Melby. Defendant appeared on his own behalf. Like I said, Jerome was an attorney. A jury of talesmen were called, impaneled and sworn to try the issues in the case. Lawrence V. Morgan was the only witness called for plaintiff, and defendant testified as the only witness in his own behalf. Plaintiff brought this as the common law action for the recovery of the possession of Lot 19, Fairview Beach, Scott County, Minnesota. Plaintiff claimed title of the real property in question by foreclosure of a note and mortgage deed dated May 8, 1964, which plaintiff claimed was in default at the time foreclosure proceedings were started. Defendant appeared and answered that the plaintiff created the money and credit upon its own books by bookkeeping entry as a consideration for the note and mortgage of May 8, 1964, an alleged failure of the consideration for the mortgage deed, and alleged that the sheriff's sale passed no title to plaintiff. The issues tried to the jury were whether there was a lawful consideration and whether defendant had waived his rights to complain about the consideration, having paid on the note for almost 3 years. Mr. Morgan admitted that all of the money or credit which was used as a consideration was created upon their books, that this was standard banking practice exercised by their bank in combination with the Federal Reserve Bank of Minneapolis, another private bank. Further, that he knew of no United States statute or law that gave the plaintiff the authority to do this. Like I said, they don't have the authority to do it because Article 1, Section 10, Clause 1 of the United States Constitution clearly says that they're not allowed to do that. Plaintiff further claimed that defendant, by using the ledger book, created credit and by paying on the note and mortgage waived any right to complain about the consideration and that the defendant was stopped from doing so. At 12:15 on December 7, 1968, the jury returned a unanimous verdict for the defendant. Now, this was unanimous. This wasn't just, by the skin of the teeth. Everyone agreed that this was true, because it was true, and still is. Now, therefore, by virtue of the authority vested in me pursuant to the Declaration of Independence, the Northwest Ordinance of 1787, the Constitution of the United States, and the Constitution and the laws of the state of Minnesota not inconsistent therewith, it is hereby ordered, adjudged, and decreed that the plaintiff is not entitled to recover the possession of Lot 19, Fairview Beach, Scott County, Minnesota, according to the plat thereof on file in the Register of Deeds office. That because of failure of a lawful consideration, the note and mortgage dated May 8, 1964, are null and void. That the sheriff's sale of the above described premises held on June 26, 1967, is null and void, of no effect. That the plaintiff has no right, title, or interest in said premise or lien thereon, as is above described. That any provision in the Minnesota Constitution, in in any Minnesota statute binding the jurisdiction of this court is repugnant to the Constitution of the United States and to the Bill of Rights of the Minnesota Constitution and is null and void, and that this court has jurisdiction to render complete justice in this cause. The following memorandum and any supplementary memorandum made and filed by this court in support of this judgment is hereby made a part hereof by reference by the court dated December 9th, 1968, Justice Martin V. Mahoney, Credit River Township, Scott County, Minnesota. And this is the memorandum. Let me just grab some water real quick, sorry. The issues in this case were simple. There was no material dispute of the facts for the jury to resolve. Like I said, it was a unanimous decision. They were all in complete agreement because the facts were self-evident. It was true. The plaintiff admitted that it, in combination with the Federal Reserve Bank in Minneapolis, which are for all practical purposes because of their interlocking activity and practices, are both being banking institutions incorporated under the laws of the United States, are in the law to be treated as one and the same bank. So like I said before, they're working as one venture, basically. So under law, they're considered one thing. And they did create the entire $14,000 in money or credit upon its own books by bookkeeping entry. So they just entered it in. It didn't exist. They created it out of nothing. That this was the consideration used to support the note dated May 8th, 1964, and the mortgage of the same date. The money and credit first came into existence when they created it. Mr. Morgan admitted that no United States law statute existed which gave him the right to do this. A lawful consideration must exist and be tendered to support the note. See Anheuser-Busch Brewing Company versus Emma Mason. The jury found that there was no consideration, and I agree. Only God can create something of value out of nothing. And these people would love to believe that they're God. Even if defendant could be charged with waiver or estoppel as a matter of law, there is no defense to the plaintiff. The law leaves wrongdoers where it finds them. See sections 50, 51, and 52 of Armed Juror Second Actions on page 584. No action will lie to recover on a claim based upon, or in any manner depending upon, a fraudulent, illegal, or immoral transaction or contract to which plaintiff was a party. So like I said, these facts were self-evident. So even if they didn't rule in favor of the defendant, the plaintiff still had no defense. That's the point. They exposed their hand in this trial. Plaintiff's act of creating credit is not authorized by the Constitution and laws of the United States, is unconstitutional and void, and is not a lawful consideration in the eyes of the law to support anything or upon which any lawful right can be built. Nothing in the Constitution of the United States limits the jurisdiction of this court, which is one of original jurisdiction with right of trial by jury guaranteed. This is a common law action. Minnesota cannot limit or impair the power of this court to render complete justice between the parties. Any provisions in the Constitution and laws of Minnesota which attempt to do so is repugnant to the United States Constitution and void. No question as to the jurisdiction of this court was raised by either party at the trial, right? So that means that they were both in agreement that whatever decision was made and is final. They're not disputing it. Both parties were given complete liberty to submit any and all facts to the jury, at least insofar as they saw fit. No complaint was made by plaintiff that plaintiff did not receive a fair trial. From the admissions made by Mr. Morgan, the path of duty was direct and clear for the jury. Their verdict could not reasonably be seen otherwise. Justice was rendered completely and without denial, promptly and without delay, freely and without purchase, conformable to the laws in this court of December 7th, 1968. Note, it has never been doubted that a note given on a consideration which is prohibited by law is void. So if they can't issue the currency legally and it has no backing or basis, it's not a real currency and it is void. It is illegal. It has been determined, independent of acts of Congress, that sailing under the license of an enemy is illegal. The emission of bills of credit upon the books of these private corporations for the purpose of private gain is not warranted by the Constitution of the United States and is unlawful. See Craig versus Missouri, 4 Peters Report 912. This court can tread only that path which is marked out by duty. Jerome Daly had his own information to reveal about this case, which establishes that between his own revealed information and the fact that Justice Martin v. Mahoney was murdered 6 months after he entered the Credit River decision on the books of the court, why the case was never illegally overturned, nor can it be. So this was Jerome Daly's own entry regarding the memorandum which I just read. The above judgment was entered by the court on December 9th, 1968. The issue was simple. Nothing in the law gave the banks the right to create money on their books. The bank filed a notice of appeal within 10 days. The appeals statutes must be strictly followed. Otherwise, the district court does not acquire jurisdiction upon appeal. To effect the appeal, the bank had to deposit $2 with the clerk within 10 days, like I said earlier, to the justice when he made his return to the district court. The bank deposited two $1 Federal Reserve notes. The justice refused the notes and refused to allow the appeal upon the grounds that the notes were unlawful, which that trial declared they were, and void for any purpose. So like I said, you can't get brought to court for using monopoly money to try and pay something or put up as credit for something, and then when you're told that it's not legitimate currency, you can't then go and use that monopoly money to pay your court bill. It makes no sense, and the whole thing is stupid. The decision is addressed to the legality of these notes in the Federal Reserve System. The case of Edwards versus Guernsey and Craig versus Missouri set out in the decision should be studied very carefully as they bear on the inviolability of contracts. That is the crux of the whole issue. So, like I said, if you want to read all the transcripts yourself and everything, you can. It is interesting and it's a good thing to study. I'm not a lawyer, but I do know that the Constitution is the supreme law of the land. And anything that goes contrary to the Constitution is null and void. I want you to look at this real quick, actually. What is this right here? This is a Federal Reserve note, right? It's from 1981, but the date on this one doesn't really matter. I just want you to see that this is a Federal Reserve note, right? Now, what is this? This isn't a Federal Reserve note, is it? It's a United States note. Why is this different than this, right? Well, one, this is not real money. This is real money. Now, when was this issued? Well, this was issued in 1963. Who was president in 1963? Well, it was John F. Kennedy. What happened to that president? Got shot in the head, didn't he? What happened to the other president who did the same thing? Went around the bankers, that is. Lincoln, what happened to him? Shot, right? So it's very surprising that people still think that this right here is money. This is not money. Federal Reserve note, which in the Jerome Daly case was decided is not legitimate currency to be used to pay for debts, public and private. This was real money. It was issued under Executive Order 11110 by John F. Kennedy, June 4th, 1963. This executive order amended Executive Order 10289 by delegating to the Secretary of the Treasury the President's authority to issue silver certificates under the Thomas Amendment of the Agriculture Adjustment Act, as amended by the Gold Reserve Act. The order allowed the Secretary to issue silver certificates if any were needed during the transition period under President Kennedy's plan to eliminate silver certificates and use Federal Reserve notes. So basically it was used as an interim thing. It wasn't going to be permanent. They were transitioning over, but they didn't like that. And I believe that's why he was killed. You also have this right here. This is so blatantly unconstitutional, I don't know how it ever got passed, but Franklin D. Roosevelt is a whole other video. That douchebag, I could go on for hours about him. But Executive Order 6102 was an executive order signed April 5th, 1933 by U.S. President Franklin Roosevelt, forbidding the hoarding of gold coin, gold bullion, and gold certificates within the continental United States. So basically he said, nah, you can't have gold. Only we can have gold. You're slaves. The executive order was made under the authority of the Trading with the Enemy Act of 1917, as amended by the Emergency Banking Act in March 1933. What are they trying to do now? They're trying to do the same thing, right? They're trying to say we have to go digital with our money because cash can be used by terrorists and terrorists are bad. Well, what is a terrorist? A terrorist is someone who disagrees with the terrorist in power. There's only one group of terrorists, and they're not the people. They're the people who run and control the people, right? But if you go against that or dissent from it, you are a terrorist, right? The limitation on gold ownership in the U.S. was repealed under President Gerald Ford, signed a bill legalizing private ownership of gold coins, bars, and certificates by an act of Congress, which went into effect December 31st, 1974. So about 40 years later, they said, oh yeah, you can have gold again. But what about the Nixon shock? What is the Nixon shock? Well, the Nixon shock was a series of economic measures taken by United States President Richard Nixon in 1971. In response to increasing inflation, the most significant of which were wage and price freezes, surcharges on imports, and the unilateral cancellation of the direct international convertibility of the United States dollar to gold. So what this did, it didn't take us off the gold standard, but it basically did. So you weren't able to exchange dollars for gold anymore, right? While Nixon's actions did not formally abolish existing Bretton Woods system of international financial exchange, the suspension of one of its key components effectively rendered it inoperative. While Nixon publicly stated his intention to resume direct convertibility of the dollar after reforms to the Bretton Woods system had been implemented, all attempts at reform proved unsuccessful. By 1973, the Bretton Woods system was replaced de facto by the current regime based on free-floating fiat currencies. What is a fiat currency? Now, this gets back into what the decision was made about the Federal Reserve notes in the Jerome Daly case. He argued that they had no value and was created out of thin air. Our system since 1973 replaced the Bretton Woods system and by de facto became a free-floating current or fiat currency system. Okay, well, a fiat currency or fiat money is a currency established as money, often by government regulation, which is what happened, but does not have intrinsic value independent of the nominal value, such as precious metal might have. Fiat money does not have any use value, inherent utility such as a cow or beaver pelt might have. So things you have of value, gold, silver, guns, ammo, food, water, whatever, back in the day when people would trade, hey, you got salt, well, I got milk, let's trade. That had value because people needed it. What we have now is useless pieces of paper which are printed to infinity, which aren't backed by anything, and which are being used to suck the wealth from this country and all the people of it to give to these people who own the banks, namely the Rothschild family, predominantly. So our currency is not real currency. You need to understand that. And you need to understand that the Constitution is the supreme law of the land. And anything in contradiction to the Constitution is null and void. Let's take the Second Amendment, for example, right? Shall not be infringed. Those are the last words of that amendment, shall not be infringed. Well, what that tells me is that any gun law that is passed is invalid, period, by default, because it is in direct contradiction to the Constitution. Therefore, I'm not going to follow it, and I don't care. I'm not going to listen to it. It's not law. Screw you. That's my opinion, right? And also, while you guys are all paying attention to the Hunter Biden stuff, which, like I said, is of no consequence because they're not talking about real issues like this, what did they do in the background? Well, the ATF, without law, decided what a pistol was. They redefined what the term pistol means. And if you don't believe me, go ahead and look that up. So while people pay attention to all this theater and this nonsense, I'm trying to get to the direct root of the cause of our problems, which is our monetary system. And when you learn about our monetary system, you will quickly soon realize that you've been lied to your entire life and everything you've been told is just complete illusion. And when you realize that, it will make you angry and it will make you want to act. And that's what we need to have happen. We need to have a bunch of people angry, willing to act, willing to get together and take our country back. And that's my goal.